Stekatee, 2 Ferndale Road in Madison. I was struck but not surprised by Sheriff Gannon's comment on welcoming communities. He said, quote, Morris County municipalities should not be declaring publicly themselves as a place where illegal immigrants can be guaranteed safe harbor from federal law enforcement officials. The challenge presented by his stance is complicated, but let's start with the most obvious. What is a sanctuary city? In Los Angeles, police will not stop people solely to establish their immigration status. In Madison, as Dr. Clyde mentioned, a welcoming community, it means government officials will not condition the provision of borough services on citizenship or immigration status. Despite all my searching, there is no one definition of a sanctuary city. By claiming it means guaranteeing safe harbor, Sheriff Gannon takes the extreme case, a logical fallacy known as an appeal to extremes. But his claim is not just a logical fallacy. His supposed remedy to have local officials enforce federal immigration policy is violative of fundamental constitutional principles. The Constitution provides 2 types of separation of powers, one between the divisions of federal government and the other between federal and state government. The latter separation is provided by the 10th Amendment. Quote, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Simply put, the federal government cannot force state or local governments to act against their will. This is known as the anti-commandeering principle and is fundamental to our federal form of government. This is a twofold impact with respect to enforcement for federal immigration laws. First, federal government cannot compel state or local law enforcement officials to enforce federal laws. And second, the federal government may not punish states or local municipalities for failing to participate in federal law enforcement. In Prince v. United States, Justice Scalia explained, the federal government may neither issue directives requiring states to address particular problems, nor command the state's officers or those in their political subdivisions to administer or enforce federal regulatory programs. It matters not whether or not policymaking is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. Prince dealt with enforcement of the Brady handgun bill, where there is indeed a jurisdictional overlap between federal and state regulatory schemes. But as the Honorable Milton Hirsch explained in Javier v. Jr., here we deal with an area of law, the regulation of immigration and deportation, reserved exclusively to the federal government. See United States Constitution, Article 1, Section 8, Clause 4. Furthermore, with respect to revoking funding or for noncompliance, in New York v. United States, Justice O'Connor explained, under Congress's spending power, Congress may attach conditions on the receipt of federal funds, but such conditions must bear some relationship to the purpose of the federal funding. Otherwise, of course, the spending power could render academic the Constitution's other grants and limits of federal authority. So, as much as Sheriff Gannon might want to enforce federal immigration policy, man, 3 minutes is short. I'm usually better at this.
You speak fast, I'll give you that.
Thank you. Can I take one more minute? Thanks. So as much as Sheriff Gannon might want to enforce federal immigration policy, our federal system of government suggests he shouldn't, as this responsibility is exclusively reserved to the federal government. Furthermore, the state and any other municipality cannot be bullied by the federal government through any form of coercion to participate in its enforcement.